Good morning, everyone. This is Rajeshkumar. Today, we are going to analyze one problem question on tort law, especially the employer's liability. The video content has been made available for informational and educational purpose only. Kindly go through the slides. Let's start with the problem question. Con, Devi, Anita, Rex, Olga, and James are all employees of a film studio, SFS. Consider the liability of SFS in each of the following events. The first event, Khan and Devi are both actors. When familiarizing themselves with the stage props, the replica gun Khan was handling suddenly discharged a bullet. The bullet hit Devi and injured her eye. Second event, Anita, a set designer, has informed SFS of her doctor's advice to avoid the solvent used in stage set painting or to wear a protective mask. Anita was required to work on a set where the solvent was used and masks were not available. Anita subsequently suffered a respiratory illness. Third event, Rex is the stage lighting engineer. A tower ladder is provided by SFS, and Rex has undertaken the compulsory staff training in its use. Rex does not always secure the ladder's safety device. One evening, the ladder collapsed and Rex was fatally injured. The fourth event, Olga usually sneaks past the James when she arrives late for work and goes straight to her office without signing the staff register. One morning, after Olga arrived an hour late for the work, a fire broke out and the building was evacuated. The staff register was checked and everyone listed was accounted for. Olga was eventually heard screaming, but by the time she was raised, she had suffered severe burns. Olga says James should have remembered that she often failed to sign in and blames him for her injuries. She started a campaign of abuse against James, who had previously been off work suffering from anxiety. He has now suffered a psychiatric breakdown because of Olga's behavior. The scenario raises various issues concerning the employer's liability under the common law negligence and vicarious liability, as well as statutory provisions. Each event involves injuries to employees in different circumstances, requiring analysis of the duty of care, breach, causation, and remoteness of the damage, along with the potential defenses such as contributory negligence. Let's deal with each event separately. The first one, Con and Devi injuries from the replica gun. Under Wilson Clyde Cole versus English case in 1938, employers owe a non-deligible duty to provide a competent staff, safe premises and equipment, and a safe system of work. The Employers' Liability Defective Equipment Act 1969 provides that employers are liable for injury caused by defective equipment supplied for the employee's use, even if the defect arises from a third party. SFS likely breached their duty by providing a defective replica gun that unexpectedly discharged. The fact that it was a replica would not absolve liability if the discharge mechanism was faulty. In Paris versus Stephanie case in 1951, it's highlighted the heightened duty of care for potentially dangerous equipment. Here, the key issue is, did SFS breach its duty of care in ensuring the safe working condition? An employer has a duty to provide a safe working environment as per the Wilson and Clyde Cole versus English case. The sudden discharge of the replica gun suggests that defective equipment or improper training. SFS might be liable under the Employees Liability Defective Equipment Act 1969, which holds the employer liable for injuries caused by the defective equipment provided by them unless they can show they took reasonable care in ensuring. In Ginty versus Belmont case, employers must provide safe equipment, whereas in the Boyle versus Quadak, the faulty equipment leading to injury establishes the employer's negligence unless rigorous safety measures are demonstrated. Hence, SFS is liable for the Davies injury A defect in the replica can constitute the breach of the duty. Let's move on to the second scenario where Anita, the respiratory illness from the solvent exposure. Employers must ensure a safe working environment, including the protective equipment. SFS was aware of Anita's condition and her need for the protective mask, which were unavailable. The forcibility and compliance with the safety. SFS was informed of Anita's vulnerability and failed to provide a protective mask. After the Section 69 of Enterprise and Regulatory Reform Act 2013, a breach of statutory duty is insufficient unless negligence is proven. SFS ignored the specific medical advice, violating their duty under Paris versus Stephanie case, which held that greater care is owed to the vulnerable employees. The absence of safety measures such as mask demonstrate a breach of the reasonable care. In Walker versus Northampton case in 1995, emphasized the duty to consider an employee's specific vulnerabilities or in other words, forcibility of harm due to the employee's failure to prevent it imposes liability. Whereas in Paris versus Stephanie case, acknowledge the duty to provide greater protection for the employees with a known health risk. In other words, failure to consider individual vulnerability increases the liability. So the SFS failure to provide masks directly breaches their duty, exacerbating Anita's respiratory conditions. SFS may argue the contributory negligence if Anita voluntarily worked despite the known risk. However, her limited options reduce the likelihood of this defense succeeding. Hence, SFS is liable for Anita's respiratory illness as they failed to provide necessary equipment. Let's move on to the third scenario, Rex, the fatal ladder collapse. Under the Employers' Liability Defective Equipments Act 1969, employers are liable for the injuries caused by defective equipment, regardless of the fault in the procurement. SFS provided training and equipment, but REX failure to secure the safety device is a factor. REX negligence in securing the ladder could partially exonerate SFS. SFS provide training on the ladder safety, meeting some elements of Wilson and Clyde Code. However, Rex's failure to secure the safety device raises question about contributory negligence. In Ginty versus Belmont in 1959 case, employers are liable for defective equipment if proper instructions are not followed. Whereas in ICA Limited versus Shardwell case, where the employees ignore safety protocols, contributory negligence or voluntary non-fit injuria may apply. In ICA Limited versus Shardwell case, in other words, employees acting against the instruction can mitigate the employer's liability. Whereas in Wilson and Clyde Cole Limited case, a duty to ensure a safe system of work, not just the provision of tools. Although SFS provided training and equipment, liability could still arise under Hudson versus Ridge, where systemic negligence exists despite the training. However, Rex's failure to secure the ladder raises the contributory negligence, potentially reducing the compensation under the Law Reform Contributory Negligence Act 1945. Hence, while SFS may argue contributory negligence, they remain primarily liable due to their failure to adequately enforce the safety practices. Let's analyze the final scenario, Volga and James fire and psychiatric harm. Employer must ensure an effective evacuation system. James' role in checking the staff register forms part of the SFS safety system. However, Volga's failure to sign in complicates the liability. Did SFS breach its duty by relying on the register? Negligence due to the delay in realizing Volga was present. Volga behavior undermined her claim. The contributory negligence applies as she habitually avoided signing the register, limiting the James liability to account for her. However, SFS system could also be criticized for failing to anticipate this issue. Whereas Volga, the SFS, might claim a contributory negligence under ICA Limited versus Chaparral due to the Volga's failure to follow the protocol. However, Hartman versus South Essex emphasizes the employer's vigilance in emergencies, potentially supporting the liability for not ensuring the actual evacuation of all the employees. SFS may be vicariously liable for Olga's campaign under Majorosvik versus Guys and St. Thomas NHS Trust case, which holds employers accountable for harassment by employees if connected to employment. James' claims involve the psychiatric injury stemming from Olga's campaign of abuse. In Walker versus Northumberland has employers owes a duty of care for employees' mental health if stress is foreseeable. In Majorovic's case in 2006, the employer may be vicariously liable for harassment under the Protection from Harassment Act 1997. James' psychotic harm is actionable if SFS failed to intervene despite knowing about Olga's abusive behavior. Hence, SFS could be vicariously liable under Majorovic for Olga's harassment. However, James' claim for psychiatric injury may also fall under Walker principle if SFS did not adequately protect him from forcible harm. Defenses on contributory negligence. In all the cases, SFS may raise contributory negligence where employees failed to follow the safety procedures or took unreasonable risk. However, the employer's non-deligible duty limits the success of his defense. Let's conclude. SFS liability varies per incident. The strongest claim is in Anita's and Davies' injuries due to the clear breach of duty. In Rex's case, the contributory negligence could limit the liability, while Olga's and James' cases depend on the specific facts of employer response and the forcibility. The Cohn and Davy, the first scenario, the liability for Davies' eye injury and the defective equipment principle. The second one, the Anita's case, liability for respiratory illness due to failure to provide protective equipment. The third scenario, Rex, liability for the fatal injury through contributory negligence may reduce the damage. Whereas in Volga, the final one, the partial liability for their burns due to her contributory negligence. The final one of James, the vicarious liability for Volga's harassment and possible breach under Walker principle for forcible psychiatric harm. Thank you.